Hello, I'm Attorney Dan Marr from the Nashua law firm of Hamblett Kerrigan. I've been practicing law here in New Hampshire for approximately 36 years and Commonwealth of Massachusetts for approximately 28 years. And during that period of time, I've dealt with individuals who have property disputes, real estate property disputes. And I've done some vlogs in regards to what the partition statute is and how you go about dealing with determining the equitable interest and the title interest of the property, and the judges have the authority to do that. But now I'm going to be talking about focusing today the actual process itself. So you have a situation where maybe you became a co-owner with somebody through an inheritance. Maybe you were in a relationship that no longer is you're no longer in a relationship and you own property together, or you and your friends thought it was a good idea to have a recreational property, but now one of you has a different, maybe you have kids and you don't want that property and the other one feels different about it, and you need to have some way to break up that property. Well, there's a partition statute that allows that, and basically the judge has the authority to determine what the values of the property of the respective people are. It doesn't have to be just what the deed says. So if it says the two of you are 50% owners, it doesn't mean that the judge has to rely on that. And they can make their own determination based upon a lot of factors. And then they also usually will, in a situation like that, they won't actually divide it. They'll actually give an opportunity for one party to buy out the other. And if that person has the ability to buy out the other, then that's fine. If they don't, then the property will be sold and the proceeds will be distributed. That's generally the way it works if somebody wants to keep the property. So in that situation, first you have to determine what the value of the property, or who has the equitable interest in the property. You can deal with both equitable and title interest. So if somebody's saying, I have an interest in the property because I moved in with my girlfriend or boyfriend and I've been paying rent, or I've been paying the mortgage, a portion of the mortgage, so therefore I should get the benefit of that. Well, it's going to be the circumstances, the whole circumstances that the court's going to look at. They're going to look at whether discussions about this. Were you paying into a general fund, and then the actual owner, the title owner, was paying the mortgage? There is rent factors that are into this, and I've argued this before when other people are taking a position that, look, I've been paying money in this relationship and for the real estate and I should be able to get a 50% interest. I say that's rent, unless there's some other agreement or some other circumstances that show that you're really a part owner and you just weren't on the title for some other reason. Maybe it was because, and I've had situations where somebody was actually going through a divorce, but the difficulty with that is if that person is hiding this asset from a spouse in one court and then they're saying in this other court, no, I have an interest in it, that person should have problems, and they do have problems. And I've successfully argued against that person in the similar situation, that you don't get to play it both ways. You don't get to claim that you're defrauding your spouse and then you're claiming an ownership interest in the property. So those issues all get factored in. The court itself, in the trial, you file a partition action. Both, you can do it in the Circuit Court Probate Division or the Superior Court here in New Hampshire. And generally I like the Circuit Court Probate Division unless there's complicated issues. While you do have a right to a jury trial, I don't know anybody that wants to have a jury trial for real estate property. It doesn't make sense. You want a judge, generally, in my experience. And you'll have a situation where the court will schedule up a time period for the lawyers or the pro se people to do discovery. There's written questions called interrogatories. There's requests for production of documents. There's possibly depositions where somebody gets is in a room and under oath has to answer questions, and generally that's a good idea to make sure you don't find out that you don't have a Perry Mason moment in court where somebody goes and says something on the stand that you didn't have any idea they were going to be taking that position. So you want to get that stuff all down, and then you go forward with a trial. Trials, my experience is they often will only last a day, maybe 2 days. They're in the probate division. I specifically find that they're done effectively, and you can get this thing done maybe within as early as at least a year, maybe even earlier. If both sides are agreeing to something, you might be able to get it done in 6 months with a good understanding of what the discovery issues are. So there might be some limited issues there that you need to deal with. If there's third-party people that you have to get in, maybe an appraiser or something, you need to account for that. Are you both going to agree to the appraiser? All those things you work out with your counsel, And it's not that bad a process to be able to make sure that you understand this. And again, the judge can deal with a variety of issues. They don't have to rely on just the deed. If it says an undivided half interest that you both are getting, that's a factor. But the court's going to look at all the circumstances. Who's contributing what to the relationship? If they're both title owners and they're both contributing, but one of them is contributing 80% of the funds for the money for the process, that may factor in. Maybe there's a factor if somebody's staying home and paying the bills. Generally, if one of the people that are unmarried are saying, look, I was providing for the child, well, there's a separate child support provision under the statute, and generally my experience with judges is marriage matters, and you don't get a property division. Don't get something of benefit because if you're providing for the household, you're providing to the real estate is really what the courts generally will factor into. But there's a lot of circumstances there. I'm happy to help. I'm Dan Marr at 603-883-5501, Hamblett Kerrigan, 603-883-5501. I've done quite a few of these cases, and I'm available to talk to you if the opportunity arises. You can also check out our website, Nashua Law, all one word, .com, and that has my weekly vlogs in there. And also I had done a radio show from December 14 to March 2023, and that was a local radio show, and those are also on the website. So happy to talk to you if the opportunity arises. Thank you.